For non-government workers with out-of-home care responsibilities, it's important to understand applications under Section 90 of the Care Act. In this podcast, we will hear why and what information is required. What are some of the common reasons for these applications?
Well, those sort of applications come after a case is finished and the orders have been made. And generally the idea is that a party asks the court to change those orders by varying or rescinding them. This is a topic that will increasingly engage those working in or for non-government organisations with out-of-home care responsibilities. These sort of applications commonly arise when, for example, a placement breaks down or the child self-locates or self-relocates. Other common reasons for these sort of applications include situations where a mother whose child was removed because of her drug addiction comes back to court some years later seeking restoration of the child on the basis that she has abstained from drug taking for a significant period and no longer presents an unacceptable risk of harm to the child. Often the catalyst for a Section 90 application is a Section 82 report that indicates some ongoing problem in the placement.
What information is required in Section 90 applications?
Well, these applications first require the party to obtain the leave of the court to bring the application, and what it is required is for the party to show that there has been a significant change in any relevant circumstances since the relevant original order. What's meant by relevant circumstances? Well, one has to look at the range of issues raised and not just at a single episode or a snapshot of events that might have occurred since the original order. A significant change must be something that's not just a minor, trivial or once-off thing, but it must be something that could justify a consideration of whether the existing orders should in fact be changed in some way. So even if the court is satisfied that there is a significant change in relevant circumstances, it won't immediately grant leave. It will then proceed to consider other additional material in deciding whether to give the leave, including the age of the child, the length of the time in respect of which the child has been with the present carer, what the plans might be for the child, and the need for the applicant to show that they have what's called an arguable case. If the party seeking to change the orders gets over all those hurdles and leave is granted, then there's another set of requirements that must still be taken into account in deciding whether the previous orders should in fact be varied or changed. They include the wishes of the child and the weight that's to be given to those wishes. And the older the child, obviously the more weight that one would give to those wishes. The strength of the child's attachments to the birth parents and to the present caregivers. The capacity of the person making the application to provide an adequate standard of care for the child or young person in the future. And finally, very importantly, the risk to the child of any psychological harm if the current care arrangements were to be disturbed or changed.
And that wraps up Part 5. In the next podcast, we will examine another section of the Care Act that out-of-home care caseworkers need to be across, Section 82 reports.